You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 39, Getting a Notice of Allowance and Your Patent Granted. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or if that's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they are members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. So we're finally back to U.S. applications. In the last 6 episodes, I talked about PCT and other issues related to foreign applications because you should at least be aware of the issues and deadlines that come up in foreign applications when you're doing your U.S. application. The last episode about U.S. applications was episode 32, and that was about what to do and expect after you file your U.S. application. In this episode, I'm going to talk about a notice of allowance. A notice of allowance occurs after a patent examiner reviews your patent application and determines that you don't have any errors and all your claims are new, useful, and non-obvious. Now, in reality, it's highly unlikely that you'll get a notice of allowance right away. Patent examiners will usually find something to reject your application for. It could be small things like typos or a drawing wasn't done right, but it could be bigger things like the examiner found something really similar to your invention in rejecting your application because it's too obvious over something else. I'm going to go over all the different scenarios for objections and rejections in later episodes, but for now, I'm going to assume the best case scenario and the examiner just issues you a notice of allowance. It's pretty simple what happens and what to do. You'll get a letter from the patent office on form PTOL 85. It will list the fees that you owe, which currently are $1,000 if you're a large entity, $500 if you're a small entity, and $250 if you're a micro entity. It's a little less if it's a design patent, but always check the patent office fee schedule for the current ones, but it should be on the form that's mailed to you. You have to check a box to verify if your status is still small entity or micro entity. If it's changed since you filed, you have to pay the appropriate fee. Also, on the form, you can change the correspondence address. You can list what names you want printed on the front page, such as the patent attorney's name or a firm name. You can have an assignee name if you assigned your invention. You can pay by check or credit card or some other ways, but credit card is probably the easiest. You print and sign your name on the form and upload it or send it into the patent office. You can also fax it in. And that's pretty much it. You only have 3 months from getting the notice of allowance to pay the fee, and you can't extend it, so do it as soon as possible. You did a lot of work to get this issued, and you don't want to have it all be for nothing because you missed one deadline. After you pay the issue fee, then it's usually in about 5 weeks or so, you're supposed to get an issue notification. The issue notification gives you a patent number and the date it will be issued. The date that patents are issued are always on a Tuesday. Technically, you don't have to do anything after you pay your issue fee. The rest is automatic. The patent will issue, and it's usually about 3 weeks after you receive your issue notification. Now, even though you don't have to do anything once you receive your issue notification, you should mark down that date because that's the final date that you will have to file what are called continuing applications. I haven't discussed continuing applications, and I'll have specific episodes about the types of continuing applications later on. But basically, if you have inventions that are similar to the invention that you just got a patent for, you might want to file continuing applications, but they have to be filed by the date that your patent issues, otherwise it's too late. There are all sorts of reasons to file them, which I'll go over in later episodes, but one of them is that if you file a continuing application, the patent office might not be able to use your own application against you in a rejection. It also helps to broaden your invention so others can't design around it. All these details I'll go over later. Once your patent issues, you usually have 20 years from your filing date until it expires. But you do have to pay some fees along the way in order to make it last a full 20 years. And I'll go over these fees in the next episode when I talk about maintenance fees. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.